And
Okay, I could start with the opening statement.
yeah, go ahead.
Okay, thank you for joining us this evening for the August 2nd, 2022 Monte Sereno Code Enforcement Appeal Board hearing. Before the hearing is called to order, I would like to point out a few house rules to assist board members, staff, and members of the public to successfully participate in this hearing. Board members, your microphone is live, so please keep your microphones on mute until you wish to speak. For tonight's meeting, we are using Zoom to host the Monte Sereno Code Enforcement Appeal Board hearing. At the bottom of the Zoom client, there are two icons, chat and raise hand. Please use chat only to report technical issues such as being unable to hear a council member speaking. Please use raise hand to be recognized by the mayor and enable to speak to the appeal board. To comment under oral communication or any agenda item, we are allowed 3 minutes to speak per agenda item. Emails limited to 350 words can also be submitted to the city clerk and be read into the record. This word limit is set to adhere to the typical 3-minute time limits. Only attendees using the Zoom application can use the raise hand option to comment. Participants calling in from a telephone will only be able to listen and cannot provide feedback or public comment. Lastly, because we are not all in the same room, all votes at this meeting will be taken by roll call. Mayor, you're on mute.
Right, thank you. We call the meeting to order. Pledge of allegiance. Councilmember Lawler, if you would grace us with leading us in the pledge.
My pleasure. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. All right, so the next item is taking the roll call. Yes, please.
Yeah, okay. Councilmember Lawler.
Present.
Councilmember Turner.
Here.
Mayor Pro Tem Makachek.
Present.
Mayor Elahi.
Present.
And Councilmember Luthold is not present yet. We have a quorum.
Yeah, he should check in about a couple of minutes. Do we have any oral communications?
We have one hand raised, but I'm not sure if it's oral communications or not.
Okay, let's recognize them and see
Okay, it's Michael Benison.
Okay, so yeah, this is for matters that are not on the calendar. So, Mr. Benison, if you want to address the issue when it comes up, you may want to wait for that.
Yes, certainly. Can you hear me okay?
Yes, we can hear you fine. Thank you so
All right,
much.
thank you. Good evening.
All right. Are there any other oral communications that are for matters that are not on the calendar?
There are no other hands raised.
Okay. Are there any written communications? I know there were some that are made part of the agenda. Are there any others?
There are none.
Okay. So we can go to the appeal hearing. I want to give Councilmember Luthold a couple more minutes, if you guys all don't mind, just kind of sitting back for about 2 more minutes so he can also join us.
He just logged in, so I'm waiting for him to accept the comments. There you go.
Oh, good. So Councilmember Luthold is just logged in. He's on mute. Welcome. If you can add him to our roll also as being present,
Yes.
that would be helpful. So we've gone through the pledge and the oral communication, the written communication. So we are now ready to start with the appeal hearing. The appeal has a procedure to follow, and it's laid in the documentation that City Manager Linares was kind enough to forward to us. But I thought it might be a good idea if Attorney Rudin could just explain the procedure that we were going to be following for the hearing itself, because I don't think we do too many of these. So if you don't mind stepping us through that, Attorney Rudin, that would be helpful.
Yes, absolutely. So with respect to this hearing, this is a civil hearing. And generally the city staff have the burden of proof. They need to prove to the enforcement hearing board by a preponderance of the evidence that the violation that they are trying to enforce exists. Each side has the opportunity to present whatever evidence or argument that they would like. Typically, with respect to these types of hearings, city staff, because they bear the burden of proof, will go first, and then the applicant will the appellant will typically have the opportunity to rebut any sort of arguments and present their own facts. And then if there are any sort of additional evidence or witnesses that are presented by the appellant, then the city code enforcement staff will have the opportunity to cross-examine those witnesses and present argument. It's up to the board to determine if there's a particular time limit they'd like to set with respect to this entire proceeding. Typically, you would want to afford both sides an equal opportunity with respect to time. So there's no specific time that is set forward in the enforcement hearings board's adopted rules. So it is up to the enforcement hearing board to determine if they need to set a time limit for this particular proceeding. So with that, Mr. Mayor, I would encourage you to open the hearing and allow staff to present their case, and then allow the appellant to respond.
Thank you very much. That's very, very helpful. And Councilmember, I'm sorry, Mayor Pro Tem Mekachek, just give me 1 second. Let me finish my thought. So that's very helpful. There was one thing that when I was going through the procedure, as far as the city attorney is concerned, it says city attorney may provide general advice, but can do both prosecutorial and advisory. And he must let the board know if he has provided substantive advice to staff to assist in prosecution. So I don't know if you need to say.
Yes, so thank you for reminding me. Yes, I have not provided staff with any sort of prosecutorial advice with respect to this matter. So if the board has legal questions with respect to this particular hearing, please feel free to ask the city attorney. So.
Thank you. Thank you so much for clarifying that. Mayor Pro Tem Mekachek, please go ahead.
Thank you. A couple of procedural questions, and these are for the city attorney. Would this be categorized as an evidentiary hearing?
Yes.
Are we, the board, allowed to ask questions, or must we be silent and only hear what the witnesses and the appellant and the city state?
The board is allowed to ask questions.
Okay. And the mayor chairs the meeting.
That is correct.
I have no further questions.
Thank you. Councilmember Turner, please go ahead. You're on mute.
In terms of a resolution to this, do we have to decide on what's going to happen today, or is this possible to move it forward if we need to visit the site?
So I would encourage that the board make a determination based on the facts and evidence that are presented to the board at the hearing. As a practical matter, this is not a land use application where you're trying to evaluate whether or not, say, a development project is appropriate and fits the character of a particular location. Again, this is a proceeding where the city staff bear the burden of proof to prove that a violation has occurred. So the questions that I believe the board should focus on are, what are the rules and what are required under the city code? And then have staff provided sufficient evidence as to whether or not a violation exists. So additionally, according to the city code, the enforcement hearing board is required to adopt written findings. There is a draft order that has been prepared by city staff. Of course, the enforcement hearing board is authorized to make modifications to that order. And if you have any, I would recommend consulting with the city attorney.
Thank you. Anything else, Councilmember Turner? Is that it, Councilmember Turner, or was there something?
Yes, thank you.
Thank you. Any other questions of city attorney? All right, if none, then I think we can go ahead and get started. There's no requirement, I understand, for anybody to take any oath or swear or do anything else. So the city staff is the first one that's going to go forward since you have the burden of proof. Please identify who's going to be testifying on behalf of the city.
Yes, good evening, Mayor and council members. I am Diana Perkins, the city's planner, and I will provide the staff report for this item tonight. To summarize the information provided in the staff report, a building permit application was submitted on June 10th, 2019 for a new pool and deck at 18011 Rose Court. 2 weeks later, on June 24th, 2019, staff provided plan review comments based on their review of the plans. Those comments are included in attachment 4 to the staff report and did include a comment that specifically noted an updated project summary form was required with the pool and the wood patio to be included in the structural coverage section of that form. The plans were resubmitted to the city on July 12, 2019, and included a revised project summary form. However, the revised form included the pool and the patio in the impervious coverage section of the form and not the structural coverage section, as was noted in the original comments. So 10 days after the resubmittal on July 22nd, 2019, plan review comments were provided by staff based on the revised plans that were submitted. The comments regarding the structural coverage requirements were more detailed as the resubmitted documents did not address the original comment correctly. The information provided at that time included specific details of the site, including that the allowable structural coverage on the site was essentially consumed by the house that was completed a year prior. At that time, the building permit for the pool and deck were canceled. On April 6th of this year, staff received an inquiry regarding the status of the permit for the pool at this address. When researching the permit records, staff found the canceled building permit from 2019. Additionally, at that time, staff found that the property was for sale and photographs of the backyard with the pool and wood deck were found with the listing online. These photographs are included in attachment 7 to the staff report. On that date, April 6th, the staff emailed the listing agent to inform them of the unpermitted pool and deck and followed up with a formal notice of violation to the property owner on April 8th. On April 18th, staff received an appeal letter from the property owner appealing the notice of violation, and the hearing for tonight was subsequently scheduled. As detailed in the staff report, the planning and zoning standards in the Monte Sereno Municipal Code clearly include swimming pools, spas, and jacuzzis that are capable of holding water to a depth of 2 feet or more in the definition of a structure, and therefore are part of the allowable structural coverage. And this was specifically noted in both rounds of plan review comments for the pool permit that was submitted in 2019. Staff recommends that the Enforcement Hearing Board affirm the notice of violation and issue a written administrative order as attached in draft in the attachment 1 of the staff report, requiring the current property owner to obtain building permits for the removal of the pool and deck within 90 days, and that the pool and deck be removed within 120 days. So this completes the staff report. I am available to answer any questions. And also present tonight is Charlotte Andreen, the city's code enforcement officer, as well as Ali Fatapour from the building department, are both here and available to answer any questions you may have.
Thank you for that. Now, it's more than question. Does the city have any other witnesses to testify on any of this? So it shouldn't just be the questions we ask, because the city has a burden of proof to show that what was done was a violation. So if the Ali or if the code enforcement officer Charlotte is going to testify, this would be a good time to do it.
The information provided in this report and as well as the written report are the accumulation of our analysis.
Thank-
So I was just sort of the presenter, but it is the accumulation of everybody's.
I appreciate that. I just wanted to make sure, because once the evidence is closed, there may not be any further evidence that may be induced. Councilmember Turner, so at this time, I guess the question is, do we go ahead with the appellant's testimony, or should we ask questions for our witnesses first?
Mayor, I would suggest the appellant be provided the opportunity to cross-examine Ms. Perkins and ask her any questions regarding what her testimony just was.
And we should wait till that's done before we start asking questions. Is that your suggestion?
Yes.
Okay, great, thank you. So let's follow that procedure, if you don't mind. The appellant, if you would like to ask any questions of the city witnesses, please go ahead. Now is a good time for you.
I have a hand raised for Stanley Watt. Ms. Perkins, is that the appellant?
Please go ahead. So there's a hand raised by Mr. Watt and by Mr. Benison. Mr. Watt, if your hand was raised first, if you want to go first, or you can switch with Mr. Benison. Either way.
I would actually, I'm happy to switch with Mr. Benison. I'll let Mr. Benison go first.
All right, please go ahead, Mr. Benison. And is there any way we can also show their faces on the screen? Would that be possible to make them part of the panel?
Yeah, they'd have to turn their video on. to do that.
Okay, if you turn your video on, we'll be able to see you also if you prefer that. If you're not, it's up to you.
I don't think we can turn on our video. We seem to be on webinar mode and there doesn't seem to give us an option to turn on the videos. We'd love to show you our faces though.
Is
Okay,
there-
let me switch them over to panelists. Give me 1 second.
And we see Mr. Watt. Mr. Benison, are you available in
I
video
just
mode?
need Mr. Benson to accept the
Okay, thank you.
panelist promotion.
Can you guys hear me okay? Somehow my screen just morphed on me.
Yeah, we can, okay, I hear you, okay, so please go ahead, proceed.
Okay, hold on. I've got to, my screen just changed and I need to be able to pull up my files. Thank you all for this opportunity this evening. And I should have let Stanley and his wife Karen speak. Can you guys hear me okay?
We can hear you, I assume they can too, yes, they're shaking.
Fantastic. Well, Stanley's the new homeowner, and I think it appropriate that we welcome them to Monte Sereno. And I wish
Welcome to Monte Sereno.
I wish it was under better circumstances. They're kind of a bit of victims in this situation, and I'd like to welcome you guys and your 2 children very much. Most beautiful town, I think, in all of California, and welcome you guys. So in addressing comments, you got to bear with me because my screen changed, guys, and I had everything laid out. I don't know what somebody did, but bear with me a minute. I have to reduce the screen to get to all of my notes, and I cannot seem to figure out how to do that right now. View options. Bear with me. Exit full screen. Here we go. Do the council members have copy of my written response for this appeal?
Yes, we do.
All right. So you understand that the Stempsons, the homeowners that originally submitted for the building permit, did everything consistent with town ordinance within Excuse me, I'm bouncing through screens, guys. You got to bear with me. I cannot get this straight here. Okay, here we go.
Mayor,
Mayor Pro Tem, Nekicek, please go ahead. You have a question?
yeah, is this the cross-examination of the witness or is this testimony? It sounds to me like testimony.
Yeah, I think he's testifying. I don't think they had any cross-examination questions unless I'm mistaken. You didn't have any cross-examination for the city witnesses, Mr. Madison, did you?
Well, I'm going to get into that in just a moment. And that's
I think as a procedural, having been through a number of evidentiary hearings, we shouldn't be mixing testimony with cross-examination.
Yeah, if you can keep it separate, that's fine, but this is still somewhat informal, so.
Well, it is informal, and normally I'd like to give the backstory, speak a little bit about, ethos, about the Stimpsons background. It's important that everyone in the council understand the full breadth of the circumstance and what's at stake. I did respond, and I made specific questions for the code enforcement officer. I believe that's Charlotte, which were not responded to in the most recent. If somebody had responded immediately, I presume it was Charlotte, and she highlighted, I'm kind of bouncing around here from background story to responding, Brian, to the evidence presented. So if you want to go forward with just and respond to evidence presented, the premise of the argument of the appeal is that Monte Sereno appears to have been conducting themselves inappropriately with regard to structural coverage. And I outlined that in my response in the appeal. And it's important. I mean, these questions are for the city attorney. It's important to understand that my background, I have a background not only in swimming pools, but in construction. And with over 350 swimming pools constructed in most of the cities in the greater Bay Area, I tried to explain in my letter without any misunderstanding that structural coverage is clearly defined within California building code and law. And it's even outlined clearly in the response. Charlotte took thank you very much for highlighting Articles 15 and 16. And if you want to go directly to those articles, we can look specifically at, in all probability, what has occurred. Do you all have access to Article 15 and 16? In the staff report response, if you highlight the staff report, you'll have to scroll way down to Articles 15 and 16, and I'd like to rebut specifically the municipal code within Monte Sereno.
It would be helpful if you can point us out to those things rather than us trying to scroll through everything.
Okay. I'll tell you what I can do for you guys. I'll just read it out verbatim if you give me time. I'm worried about time limits. I hope you guys give me a little time because I don't do a lot of Zoom, and I need to make certain that we pull it up and we can read it. Okay. So when you have the opportunity, scroll down. What Charlotte has done is she has posted the actual building code, the municipal code 10.01.020.au, and that's attachment 15. And she's put a little star in parentheses under the word structure, and that's section AU. It's a paragraph in AU. But before we read that, I'd like to scroll down to Article 16, which is the subjective that the argument's predicated upon. And that is consistent with California code, all other building departments. And when I say that, I say it with confidence. I took the liberty to reach out to Atherton and Los Altos Hills recently. I've talked to other building officials just to confirm my position, and I've known it for many years, that it hasn't gone uncontested in Monte Sereno is, it's not a big surprise, because as beautiful as Monte Sereno is, it's a one horse town, and things happen in Monte Sereno. So let me read verbatim coverage structural, which is item K in Article 16, Attachment 16 Municipal Code. And what it says specifically, coverage structural means the area measured in a horizontal plane covered by all buildings or other structures on a parcel of property or a lot, comma, as the case may be, comma, excluding features permitted to extend beyond the walls of the building or other structure, comma, by any other provision of this chapter. Now, the word excluding is a definitive term. And any other structure, as I mentioned in my response, and I'm not sure that everyone fully understood, and I didn't want to sound, like a school teacher talking about determinatives and the meaning of something in context. Structural coverage, swimming pools in no other city or town are considered within the realm of structural coverage, period. And it may be okay. Council may advise you that that's not a problem. But for someone that is a professional at this, an expert, the preponderance for architects, for builders, for designers that are submitting building permits, everyone knows that swimming pools are accessory structures. Barbecues are accessory structures. Raised structures without walls and doors, they're not habitable structures. If there's not floor area, or if it's not attached, these are not technically structural coverage. Structural coverage is very specific. And for it to be misconstrued or misunderstood within Monte Sereno is, it's one of those things. And I don't want to tell stories about, the construction procedures of yesteryear with other administrations and other mayors, because I've stood city council a couple times, and things happen administratively. Your processes and your procedures you may think that you're doing it the right way, but I can assure you a swimming pool doesn't have walls. It's not something that something is built on top of, and it's certainly not a habitable structure. So the premise of the argument is, the reason I attached the building plans for the Stimsons, and by the way, Bradley, he was owner builder on this home. And the reason I attached the other home was he's owner built 2 homes in Monte Sereno. So he has intimate working knowledge. And if you take the time, and I know that you're all busy with your other lives, to read the communications with then building official, you'll get a sense of, his proactivity. And I started in the beginning to a little bit of the backstory and the history of the Stimsons, who are the most beautiful people you could ever imagine. I've been very fortunate to call them friends and have spent time with them. Our children went through Dave's and Fisher and LG together. So we had history. Anyway, Bradley's very hands-on. When he called me, he said, I'm going to build a pool. I mean, I knew it was going to happen. He says, hey, I want to do it myself. And I want my kids, they'll be out of college. They'll be home from college. They're going to help me build this thing. I said, hey, no problem. I'll help you out. Can you do the plans for me? So I sent the plans up. I reviewed his submittal for his home. And we had a brief conversation. I said, hey, things are tight here. Well, I have just enough impervious coverage. I said, he said that he had consulted with the building department and with Rob. And again, this is an owner builder that knows the drill. And I didn't think twice to look at structural coverage because I know that swimming pools don't belong there, even though this is where they are in Monte Sereno. So the lot coverage available for accessory structures and other appurtenances, barbecues, hardscape, et cetera, was about 800 square feet, if I'm not mistaken. And the project barely fit into that parameter. So we put together the plans, we shot them off, and there you have it. Now, before I continue with the story, I want to scroll back to Article 15 so that everyone understands. And I understand that there, I believe, there's 3 attorneys on the panel plus the city attorney. Article 15 or attachment 15, let's go to structure. And please listen very carefully, because this is verbatim California code with the exception of the last paragraph. Structure means anything constructed or erected, comma, the use of which requires location on the ground or attachment to something having location on the ground. For purposes of this chapter, and this is important, swimming pools, spas, and jacuzzis, whether constructed above or below grade, which are capable of holding water to a depth of 2 feet or more, shall be considered structures subject to city building regulations. Equipment appurtenances appurtenant to operation of swimming pools and spas, jacuzzis shall be treated as accessory uses. Now, the word structure, meaning anything constructed or erected, is a definitive term. And I've asked for a response. If there's another building regulation, I don't see it. You have the opportunity to call it something else, but you haven't. It's not in writing, and it would have to be predicated on something highly unusual, like somebody in the past that exceeded their impervious coverage and tried to squeeze a swimming pool in under the structural term. It's just illogical. The preponderance of evidence, factually, in the state of California, everyone is looking at it a different way. This is a problem. Now, Bradley was wrong to continue with the construction of the pool. And he knew that. And I was under the presumption, and the reason you have full evidentiary of the constructed of the structure, I said, hey man, this is a no-no, but if you're going to do this, you're going to have to face the piper. At some point, you're going to have to run over and take this through planning commission. And that's why you have photos and tape measures and depth of conduit and bonding clamps and electrical features, all for purview for the building department. And I saw Ali on earlier. I don't know if Ali's in, but Ali has seen these structural engineering plans a million times. So holding a tape measure to a steel structure, he can see that, you know, the steel schedule 6 on center. He can see that the gunite was applied by a licensed contractor. And I think, without wasting a lot of breath on this, there were some other mistakes at the building department that are procedural within the staff. And in my response, I attached everything, but I'm going to presume that you all didn't look at it all because I know you're busy. One important thing to understand is that the building official had responded to building questions prior to notification that we didn't fit within the parameters of planning. Now, this is a problem because, once again, there are procedural requirements for building departments. And that is, we don't go past check A and move on to check B if we don't conform. So the false start, and also I want to elaborate on starting the project without a building permit. It's not uncommon for contractors to start if we're deep within the permit process and past to planning, and we're waiting on structural, mechanical, and electrical. These are common practices. And even within Monte Sereno, to prep the site, clear the site, stake out forms, I believe we can even move up to, it used to be 200 yards of dirt. This pool isn't anywhere near that parameter. But you can even move a substantial amount of soil, which would include, in all probability, the entire excavation prior to permit issuance. So these may seem like, hey, how could this guy jump the gun? Well, if you go back and read the communiques between him and Rob, what you're going to see is a proactive homeowner. And Bradley, I mean, just to give you his background, Bradley was the VP of engineering at QuantumScapes. And this is a company that has received hundreds of millions in investment and had folks like Elon Musk on the board. It's revolutionary, new lightweight lithium-ion technology. This is a guy that is
Mr. Venison, Mr.
Yeah.
Venison, yeah, can I give you, can you wrap it up in about 5 minutes?
Yes.
Then let's see how much time we have at the end, so we can move.
Okay. So the premise of the argument is almost irrelevant at this point. I'd rather address all of you in an amicable manner. And that being, we'd like to address this as a code violation, like we do other code violations. I'm also engaged in representing clients with other code violations. Typically, we'll bring in a civil engineer or a geo or a surveyor, whatever's required to bring the structure current. Demolition of something that's beautiful on a home that was just constructed and sold for $5.2 million, and comments from a building planner who's no longer with the planning department. Essentially, the verbal conversation was, you can't do anything but plant flowers in your backyard. Now, I want to address also the errors made by the building department. One more, I asked the code enforcement officer to respond to specific questions, which none of the questions were responded to. And it's important that you all understand the second question, which I'll address first. I want to read it as quickly as possible. That was from Jeannie, I believe it was, Jeannie Hamilton. Let me go back. In any event, let me read it as quickly as possible because it's just wrong. I mean, any deck that is subject to a building permit is considered to be structural coverage. The proposed deck exceeds 200 square feet, therefore subject to a building permit, and again, would be considered structural coverage. The same comment as above, there is little or no capacity left to accept any additional structural coverage. So here we have an argument. Your planning at the building department is calling decking around a swimming pool structural coverage. Now, this is fundamentally wrong within municipal code, and it's just wrong. Code enforcement did not respond to the question. I put in underlined parentheses very specifically, please note that this comment is incorrect. I reviewed plans dating back 18 years in Monte Sereno, and pool decks are impervious coverage and or adjusted relative to pervious material. Decks around swimming pools, walkways, driveways, etc. So here we have falsus in uno for the attorneys. If we go up, the structural coverage argument I've just made, and it's factual. I would encourage all of you to take your time, reach out to other building officials, and understand that swimming pools are not considered to be structural coverage. Structural coverage is a very specific term relative to habitable structures, period. So this misunderstanding at submittal, jump starting on the pool, which is not uncommon, it was wrong to continue, admittedly. But I think there's been enough penalty here. We've got a beautiful structure. We've got a new beautiful family. I've offered to stand inspection on the project. I've presented all of the documentation consistent with California Building Code, showing that it is current. And I'd really like to see council with some consideration for this young, beautiful family with their children, 8 and 5. I think for this town to even consider for a moment that you can construct a home and not be able to put anything in your backyard. I mean, it should have been caught at the front end during planning and architectural and planning review at the beginning. Bradley was under the impression that it was. Bradley was misled. Bradley made a mistake. And I'd like to have this structure approved, consistent with California code. As I mentioned in my letter, I stopped over 3 or 4 weeks ago, met with the Stimsons. I reviewed the project. I asked them to change the springs on the gate. We put some I said, put some GFCIs on this, take this bonding wire and run it down to the equipment room. There was 3 or 4 items that were shy. And I'm really speaking out at this point to Ally in civil.
Thank you, Mr. Benison. I did want to reserve some time for Mr. and Mrs. Watt if they wanted to speak. And then there's the city can cross-examine you guys.
Thank you. Thank you. Thank you very much for your time.
Thank you so much. Mr. and Mrs. Watts, if you would like to, I think you have at least 10 minutes, so go ahead.
Oh, appreciate that. Thank you, Mayor. I just want to introduce, my name is Stanley Watt and my wife is Karen Guo. We have 2 children. Sorry about that. You can see one of them now. We have an 8-year-old and a 5-year-old. This is our 5-year-old. Our 8-year-old is a boy. And we've just been excited to be able to move into Monte Sereno. We've been looking for, we're coming from Palo Alto. We want to move a little bit farther south. And Monte Sereno seems like a beautiful town, beautiful city, excuse me. We've actually been looking for houses for almost a year, and we decided that Monte Sereno was such a beautiful city that we want to live there. And so we're really excited to be able to move there. The pool, we think, is a wonderful feature, and we'd love to be able to use it for our kids and potentially neighbors who might be our friends and things like that. But I will admit that I wasn't part of the process, so I don't know exactly what happened and what transpired, but at least this is my understanding. My understanding is that the former seller or the former builder built the pool. He has built at least 2 houses on Monte Sereno. And my understanding is he's a very well-respected person of the community. He's built 2 houses all to code and well done is my understanding. My also understanding is that as he started to build, my understanding here is that I don't think he intentionally tried to subvert the code or tried to do anything nefarious. I think what happened was that he did start the process. I saw documentation that suggests he started talking to the building department as early as March. I think March 10th was the documentation that I saw. He got approval from the building department, and he got some communication from the building department, and he told me that all of those concerns were very, very minor. And so he felt it was very easy to take care of. He didn't expect that there would be any problems with the planning department, primarily because structural coverage, at least his understanding was the pool would not apply to that. And it seems, although that might not be the case in Monte Sereno, it seems like maybe there's some inconsistency and maybe it's understandable that he didn't understand that. So I don't think it was an attempt to subvert the rules, but that is what he eventually did. We would, if possible, love to be able to keep it. I think one of the concerns that we have is that if we're asked to remove it, we're kind of concerned about what that does to our neighbors and all of that. Like, I think we've looked into this, like we've tried to take this seriously. We know we have to take down the fences. We have to bring in an excavator to our neighbors' lawns. And we're actually just really worried that doing this is going to create even more disruption than leaving it. So respectfully, we would just ask that maybe you could consider those things. I don't know all the history of what happened, but I'm not sure if at this point it's better or more beneficial to come and destroy this and create such inconvenience. I know, to Michael's point, there is conversation about decks. I don't know enough about the details, but looking at what's on the screen, decks don't seem to be considered part of structure, like it's not written there, so we're not really sure what that means either. Again, we're not experts. We appeal to you, and we really appreciate the opportunity to be able to live here.
And I'll just add that, and first of all, thank you so much for all your time. I'm sure you have lots of things to do on a Tuesday evening, so thank you so much for your time. And thank you for welcoming us to the city. I just wanted to add additional context, which is we were drawn to this house specifically after a whole long year of looking because of the small pool. We have 2 small kids, and they love nothing more than splashing in water. So that was one of the biggest appeals of this house, and why we took out a huge loan to purchase this house. and it was only in the 11th hour, like literally the night that they were accepting offers, and we had submitted an offer, that the seller's agent called us and said, oh no, like we received this notice from the city that like they want us to destroy the pool. And we were kind of paralyzed and didn't know what to do, but you know, it was the 11th hour, and we just you know, that's when we found out that this might need to be destroyed. So I think on multiple levels, we just hope that you can consider some lenience, given that like one, it would cause a lot of destruction and tremendous expense to the neighbors and also ourselves, to kind of take down fences and go, like, I think we have to mow through our next door neighbor's property in order to just fit an excavator, because it's a very narrow side gate. And then two, please understand that like, I think the previous sellers or owners were trying their very best to follow everything, and like they made an honest mistake. And you know, I don't know if this is relevant, but like the kids would be so devastated to lose this pool. They've only played with it like a couple times, and they're kind of don't understand why it has to be destroyed. And if none of that resonates with you, just as a matter of policy, it sounds like Monte Sereno is the only city among all Bay Area cities that views a pool as structural coverage. And so, you know, we always think that it's good to have consistency of policy whenever possible across jurisdictions. It also avoids, you know, surprises for people. So if you could please consider that, we'd be really grateful.
Thank you very much. I guess this would be the time for cross-examination. So if the city wants to ask the appellants any questions, this is your time to do so. If the city staff wants to ask any questions, that would be Ms. Perkins or any member of the city. If not, just let me know so we can go on.
Yes, I do not think we have any questions.
All right, thank you. Also at this time, if the appellant wants to ask the cities and do any cross-examination, I know there was a couple of questions that Mr. Benison raised. Would the city care to answer those questions? And if Mr. Benison, if you want to repeat those questions, that might be helpful.
Yes, certainly. In simple terms, I think that it would be appropriate for staff to acknowledge that hardscape, whether pervious or impervious around a swimming pool, is not structural coverage. This was an outstanding mistake.
All right. So if you want, does the city want to respond to that question?
Yes. So a pool deck. So the decking, any concrete around the pool at grade level is not counted in the structural coverage. That would be counted towards impervious coverage depending on the materials. But as clearly indicated in the definition of a structure in our zoning code, the pool itself is a structure and included in the structural coverage. This section on the screen right now with the structural definition and the structural coverage are zoning standards. These aren't building code standards, and zoning standards are unique to each jurisdiction. So it may be that a pool isn't considered a structure in other jurisdictions, but based on the definition in the Monte Sereno Municipal Code, it is in Monte Sereno.
All right. Any other questions of the cities, Mr. Benison or?
Yes, and the second question, and it's important that I think it's really important that these planners understand, is that the definition of structures, the word structures is singular. It doesn't say covered structures, and this is important. Structures is a vague and ambiguous term, and I'm trying to be, you know, you guys, I'm sure, are all beautiful. I don't even want to be in this position to be having this discussion. Structures is vague and ambiguous. Our cells are structures, our bones are structures. Everything's a structure. Things have to be put into context relative to the determinative that it's being used. And this is very, very important. I used the word moments in my rebuttal. And I can go on and on, whether it's, you know, deciphering ancient text, you have to be clear in your understanding. And I think at some point, the building department, I don't even want to have this conversation. I'm sure, I know you guys are all beautiful. Structures is not, it's not a habitable structure. Structure is a separate term. And you guys have to understand that. You have to read through the word and keep it in context. And I think that's important. What has happened, in my opinion, is that someone administratively at some point, there's a form, there's a document, there's something within planning that has moved that word and that misunderstanding categorically into the wrong place. And it may be predicated on some special circumstance in the past. I'm only trying to guess theoretically why this would have occurred. But because a building department exercises a particular practice for 10, 15 years and it goes without being contested, it's not a big surprise in Monte Sereno. It's a small town, but it just is incorrect. And I'm sorry.
Thank you, Mr. Benison. I think you're probably making your closing argument, which you have a right to do.
No, I'm ready to keep closing, but I really don't want to be in this position. I love Monte Sereno. I love all the people involved, the few conversations with Stanley. And I just found out last night his kids, he said, we went to move in and the kids ran straight in the backyard, and jumped in the pool. I just want to cry over here. And I know Brian, he's a hands-on owner builder. He's been through the drill. So I think he can relate to Bradley. Sometimes, you take a crowbar to something, it's not right, but it is what it is. I've taken my time to make sure that it was done right, and that most importantly, the meeting several weeks ago was predicated upon safety. That was the most important thing. And I made certain that the pool was consistent with code. I think, and I hope, and I'm going to laugh, and maybe Stanley will as well, because he corrected some of my language. I said that I thought it was done in good taste, and he came back and said, shouldn't we say it was done in good faith? And I was referring to it being befitting the home. And if I would encourage all of you to visit this home, because the home's built by Bradley. I'm going to just tell you right now, it's a Swiss watch. It's gorgeous. And he has not only increased the value of all the homes on the street, but he did it once before on Bradford. It's like Brian, these homes are, his homes are, it's a jewel. And those three little fountains, I just want to put things in perspective, that you see in one of the images sent. Those are laminar colored fountains that light up at night. And, I charge about $3,000 to install each one of those. It's got $9,000 in fountains. It's just a beautiful structure. It would be an abomination to even consider another option. And that's all we're asking is let's try to figure this out and get on down the road.
Thank you, Mr. Benison. Mr. Miswat, you have 5 minutes if you want to make any closing statements.
Oh, I don't want to keep everyone really late. I think I already made some points. We made some points earlier. Just wanted to provide one piece of additional context, which is we're talking about a very small pool. It's more like a splash pond. It's most of it is like just a couple feet deep, or even like 1 foot deep, and then at its deepest is just like 5 feet for like a tiny little area. You can't even swim more than 2 strokes. It's just really ideal for kids, but we're not talking about a huge monstrosity or an abomination that like takes over the backyard. It's quite small in terms of width and depth. So like perhaps some of the concern, I'm guessing, I'm not a policymaker, some of the concern could be like, well, we don't want people covering their backyards with like a huge pool, right? Because that could be an eyesore. This is anything but. It's just like a tiny little splash pond that kids like. So I don't know if that's helpful. We'd really be grateful if we could. We're happy to, like, although we were not involved, like we're inheriting the situation. We're happy to pay a fine, or like anything to try to make things better or right. I am really worried that like, if we do need to destroy this, we will need to like cause damage to the neighboring house, which is very close to us. With that narrow side yard, like tear down that fence, and they probably have vegetation and planters there. And I don't even know how they're gonna react when we say we need to do that to like get an excavator in. Anything you wanna add?
No, really appreciate
Yeah,
your time
really
and
appreciate your
really
time.
appreciate you listening to us. And I think Miss Turner, I'm sorry, I'm not sure I know what's the right way to address you, Councilwoman Turner. She suggested if she wanted to look at it, oh, we certainly welcome you
Yeah,
anytime
we'd
if you'd
love
like
to
to look
meet
at it or anything
neighbors.
like that.
Including you all.
Thank you.
Thank you.
Thank you very much. Does the city have any closing statements to make? You got 5 minutes. Staff, anybody from the city?
Just to sort of summarize, I think the information that we have in the staff report is pretty clear. Again, the definitions referred to of a structure are zoning code standards, and it is a specific definition of what is considered to be a structure specific to the Monte Sereno zoning standards. And then the information also provided in the attachments, number 4 and number 6, which are the plan review comments that were provided in 2019. Both of those reviews did include comments related to calculating the structural coverage of the lot with the pool. So staff does not believe that there was any delay or or not complete review of the plans that were submitted at that time. And I think that wraps up the information that we have to present for you.
Thank you very much. I know the city is in a position, you're in a tough position presenting the city on this. Nobody wants to take drastic steps on some of this stuff, but somebody has to do the work, I guess. This is the time for council members to ask, or I guess we're the examining board at this point, to ask this any either the city or the appellants any questions. So, Councilmember Turner, did you want to go first? You're on mute.
Yes, I have some questions. To me, it seems like there is a standard definition for what structural coverage means, as well as impervious coverage. And from what I'm hearing, and I need, I guess, planning or a city attorney to make a comment on this, is that Monte Sereno is not adhering to the industry standard for the impervious and structural. Is that correct?
So I don't know if there is a specific standard industry-wide. I will say, though, that the city is entitled to make its own rules with respect to lot coverage, including impervious coverage or structural coverage. Not every city has definitions of impervious or structural coverage in their code. A lot of them just regulate the total amount of things that you can place regardless of what they are called. And I think for the enforcement hearing board's decision-making, I think that the key issues that the board should focus on is, what do the city's rules require? And in that respect, the enforcement hearing board does have some authority to interpret the city's own code when considering this violation. And additionally, the other question presented by this particular issue is a building permit required for this improvement? And was a building permit obtained, or was it constructed without a building permit? So, depending on how the enforcement hearing board interprets the definition of structural coverage, and whether or not a pool is considered a structure for the purposes of structural coverage, the enforcement hearing board has the authority to determine that it is a structure subject to the structural coverage requirements. And in which case, this, as city staff have testified, this particular improvement would exceed the bounds of what is allowed under the city's code, and it would be a legal improvement and would require removal typically. If the council or if the enforcement hearing board determines that it is not a structure that is subject to these structural coverage provisions, then the council would need to still or the enforcement hearing board would still need to consider whether or not that this improvement still requires a building permit. And then, assuming it is allowed by the city's zoning code, the improvement would still need to go through and obtain a building permit for the improvement and go through the verification process. And that may require, inspections, et cetera. But, I think the first issue for the enforcement hearing board is this a violation of the city's structural coverage regulations? Because if the answer is yes, then you don't necessarily need to consider whether or not this is something that, may still require a building permit.
Thank you. Any other questions, Councilmember Turner?
No, I can ask them later. Thank you.
All right. Anybody else have any questions? I'm sorry, at this time, the evidence is closed, so only the city council people can ask questions at this time. Councilmember Lawler and then Councilmember Luthold.
Thank you, Mayor. This is just again, a legal question for the state policy 105.2 work exempt from permit that was brought to our attention. It does say exemptions from permit requirements of this code shall not be deemed to grant authorization for any work to be done in any manner in violation or any other laws or ordinance of this jurisdiction. So I take that to believe that city municipal code supersedes state code. Is that correct?
So this is a provision of the California Building Code, and what is provided in the staff report is the 2016 version. The city has since adopted the 2019 version, but I will tell you that based on my investigation, that the provisions are identical and are the same. But I believe you are correct that persons are required to comply with both local municipal codes as well as California building code requirements. The California building code requirement exempts from building permits certain kinds of improvements which are set forth in 105.2. But that doesn't necessarily mean that you may not be required to get other permits from a city.
Okay, thank you.
Councilor Luthold.
Jim, I believe this is directed to Ms. Perkins, and that is looking at the overview of the site, just the Google Earth view, it appeared to my eye that the driveway plus the coverage for the deck plus the patio plus the pool looks just to the eye plus the house to cover probably close to 85% of the lot, maybe 80%. Ms. Perkins, did you do any investigation or summarizing or calculation that would tell us if this pool is impervious surface, but not treated as structure, are we over the pervious and impervious is one question. And part of that also is, it didn't appear to me that the patio and all of the pavers in the patio were part of the original building plans either. How would that factor into pervious and impervious coverage as it exists there today on the site?
So for the existing coverage requirements, we relied on the information provided on the approved set of building plans, which were approved in 2016 for the new house. The information that was provided and approved by staff at that time has a total structural coverage of 39.97%, which is 3,774 square feet of the lot. And with that permit, a total of 51.8% of impervious coverage was approved, which equals 4,890 square feet. And on the plans that were approved, it includes a new pervious paver driveway, And our policy is to consider pervious pavers, just to count 50% of that area towards impervious coverage. And there were, those plans approved did not show any coverage or improvements in the backyard. So if there has been additional coverage installed since the building permit was issued, that would need to be included in the revised calculations to determine if there is enough impervious coverage left for the pool. Based on the building permit that was issued in 2016 without any backyard improvements. Let's see here really quick.
And if I may interject here, the notice of violation for this particular proceeding pertained to the pool and deck structures only. And while these may be some issues for further investigation and enforcement proceedings, I don't think that those issues are germane necessarily to what is being presented to the Enforcement and Hearing Board on appeal today.
Okay. Councilor Lethal, do you have any other questions?
No, thank you. We do have some time limitations today, so I'll let other people ask their questions and then we can get to our decision-making process.
Councilmember Makachek, did you have any questions?
Yes, I've got a couple of questions. One thing I would like to do is take a 5-minute recess. So I'd like to build that in before our decision because I'd like to go through some calculations. And this is a question for our city attorney. Is it possible to ask for any type of a variance with respect to something like a swimming pool? I know that variances can be requested for a building, being a house or some other structure, but what about for a swimming pool? So that's a very succinct question. Could the applicant have requested a variance for this swimming pool?
Yes, the applicant is entitled to apply for a variance with respect to the city's zoning prohibitions and zoning standards. That being said, the standard for granting a variance is usually very difficult to meet. And I will just say that the standard is in Government Code 65906, so it's pursuant to state law, not local law. And the applicant would have to prove that because of special circumstances applicable to the property, including the size, shape, topography, location, or surroundings, the strict application of the zoning code would deprive that person of privileges enjoyed by other property in the vicinity under identical zoning classification. And typically, the local agency cannot use a variance procedure to grant a person special privileges or exemptions from the zoning code. It really has to be, usually a demonstration of hardship due to the particular property configuration, something very unique about the property that would mean that they're not able to comply with the city zoning regulations and still have the same kind of enjoyment that everybody else gets.
Understood. My second question for you, Mr. Rudin, is, and I think the terminology is the jurisdiction having authority. Is that the correct term? Who is the jurisdiction having authority in this?
So you're using, I believe, terminology from the California Building Code. With
Yes.
respect to jurisdiction having the authority, that would be the city of Monte Sereno in this instance.
Okay, thank you. Those are my questions. I don't have any questions for the applicant, and I don't have any questions for the city. I would like to spend a few minutes before deliberating this.
Okay, any other council member have any questions? All right, let me do my analysis. I mean, as I go through the definitions, and we have to remember the city has the burden of proving that whatever we are doing is correct. It's not the appellant, it's us. So as I look at these definitions that Mr. Benson so kindly pointed out, the structural coverage is very specifically defined under K. So when you have two definitions of structure, one under attachment 15, which is basically just a generic definition of what a structure is and includes pools. And then there's a very specific definition of structural coverage, which clearly defines as a pool not to be part of the coverage because it's beyond the walls. So when you have a specific definition in the code, you follow that definition. You don't follow generic definition when there is a specific definition. My understanding of today where we are is that what's been violated is the structural coverage percentage. And if a pool is not considered part of the structural covered under a very specific definition, then there is no violation in my mind. There is no structural coverage issue here. There's only an issue of, there is a violation of a permit because the permit was not obtained on the pool, but it's not a violation of the structural coverage. And that's my reading of the interpreting the statutes. The other thing that bothers me on this is when Mr. Quintero originally sent out, when the pool application was brought before Mr. Quintero, and I guess there's a question whether he should have been added. At that time, the letter he sent them, he said, okay, your equipment's got a problem, your vacuum's got a problem, your piping has got a problem. I mean, he talked about everything around the pool as having some problems that needed to be fixed. And those were the comments. And then the applicant came back and said, okay, this is what we've done to fix it. There was no mention in Mr. Quintero's letter that you can't do the pool. It's above the building permit requirements. It's above the 99% requirement. I mean, that should have, I mean, why do you even get into the accessories and the equipment and the structure of the pool if a pool can't even build? So that's what bothered me. And the letter that went out came from Ms. Hamilton, the planner, saying, okay, now this is above the percentage. I don't know if Mr. Quintero ever sent a letter or not, who's the building inspector. So keeping those two things in mind, I think we need to look at getting this thing regularized. There is a violation of the permit because the pool permit was not properly obtained. And there may be some other violations and that need to be looked at and we should proceed accordingly. But I don't think there's an issue on structural coverage. And to the extent other cities allow pools not to be structural, that makes sense. And also if you think about all the ADUs that are being built, all the extra buildings that are being built on lots now, I don't think we're there where we need to worry about the intensity or density of property things on it. Those are my thoughts. Ms. Perkins, if you can specifically respond to why a structural coverage definition should not be considered and just the structure definition should be considered when we're looking at these code sections. That might be helpful.
Yes, thank you. So the definition for the structural coverage includes the area measured in a horizontal plane covered by all buildings or structures on a parcel or property, and then excludes features that are permitted to extend beyond the walls of the building or other structure by any other provision of this chapter. So those would generally be roof eaves or awnings that extend off of a building would not be included in the structural coverage. But back to the first part of the structural coverage definition, it means the area measured in a horizontal plane covered by all buildings or other structures. So then referring back to in the same municipal code section for our zoning standards, the same section of definitions is the definition of what a structure is, which does include swimming pools and spas that are capable of holding a depth of 2 feet or more of water. So that is why we include the pool in the structural coverage calculations.
All right, I understand that's the city's point of view. Thank you. Let's see, Mr. Benson, I'm sorry, but the evidence is closed, so that's why I'm not calling upon you. Councilmember Turner, please go ahead.
And Mayor, actually, to the extent that any new issues are raised by city staff in response to council member questions, it is actually appropriate and required that we recognize the appellant to respond to any new issues that are raised, because the answers of staff are considered evidence for the purposes of this proceeding.
Thank you for covering that. And Mr. Benson, I'll come back to you if you think you have you're going to be responding to some new issue, then we'll definitely give you time to do so. At this time, Councilmember Turner, let's the council keep going.
Yes, from what I'm looking at here, I think the definition of structural is out of step with the general usage. But I have a question here. If I were to look at the pool, is there anything from the pool, the size of the pool, that inhibits the safety, the fire, or obstruction of passageway, or for safety reasons, or for fire evacuation? Are those any, I mean, do they inhibit any of that? And I guess that's for the planner.
So setting aside the structural coverage requirement issue, the pool does meet the other setback requirements for a pool. Regarding sort of the safety issues of the pool, I don't believe staff can comment on that, as we didn't complete any inspections during construction.
Anything else, Councilmember Turner?
Yes, I think unless there is some serious problem with leaving the pool and the decking in place, I think that goes beyond merely being slightly out of spec with the code. So I would like to take that into consideration. I would like at least the council to look at that and take that into consideration as well. Thank you.
Councilmember Lawler?
Thank you, Mayor. For one, this is a really unfortunate situation. The fact is, the seller did not disclose to the buyers about this unpermitted work until the agent actually called the city. So that's irresponsible. The fact that the seller also has built before in the city, so he should have really, he was intimately aware and had intimate knowledge of building in Monte Sereno. So, but that's beside the point. How do we move forward? I understand. I would love to see you keep your pool. I would like to see a compromise in some way, you know, because I know that the decking was also part of this coverage, this structural coverage that is creating this issue. And I'm wondering if we could potentially remove that decking and replace it with pervious coverage, because I think the problem is really it's the impervious nature of the structure. And so I guess this is a question for our attorney, if that kind of compromise is something we could work with.
So the enforcement hearing board's job in this instance is to determine whether or not there's a violation rather than to reach a compromise between code enforcement staff and the applicant. Now, whether or not the decking should count as impervious coverage or structural coverage is, I think, a live question to be considered by the enforcement hearing board as part of this proceeding. So it is, I believe, the city's position, and perhaps Ms. Perkins can make clear whether it's the city's position that the deck also counts as structural coverage or whether it counts as impervious coverage. You know, I think that the city, the city's enforcement hearing board needs to make a determination as to whether or not the pool is counted for the purposes of the city's structural coverage limit or not.
All right, thank you.
Let's see, Councilmember Turner, you have your hands up again. And you're on mute.
Yeah, yes, I'm on mute. So what I'd like to propose here is that we grant a variance permitting the pool and the decking, and we ask the owner to pay the appropriate fees, and we welcome our new neighbors to Monte Sereno.
That is unfortunately not a viable option in this proceeding, as a variance must be properly noticed and can only be approved by the city council. It cannot not be approved by the city's enforcement hearing board. So, if the enforcement hearing board wants to continue this proceeding, it can do so without making a decision, which would authorize the applicant to submit an application for a variance, which would go to the Site and Architectural Committee first for recommendation and then go to the City Council for action. But before you today is not an application for a variance, and you cannot, in accordance with the Brown Act or planning and zoning law of the state of California, approve a variance today.
Anything else, Councilmember Turner? All right, Mayor Pro Tem Mekachek.
Yes, well, it seems like we moved immediately into deliberations, and if we're going to be deliberating, then I'm good with that. I wanted to have a recess, but I noticed that Mr. Bennison's hand is up, and I don't want to continue deliberating until we close the until we close hearing from the witnesses.
All right, so there are no other members from questions from council member. Mr. Bennison, if you have some new question that you want to address, then we'll reopen the hearing for you.
Yes, I'd like to respond. Oops.
You're on mute.
Hello? Hello?
Go ahead.
Can you hear me? Yes, I'd like to respond first to Sean. We talked about coverage and lot coverage and your apparent view. I went through the math and there was 774 square feet remaining on the property. The pool's 259, that left 515 square feet. Another question came up, I believe it was Liz. There is all pervious coverage. There are pervious pavers and pervious wood deck around the pool. So that would allow us 1,030 square feet. I think I haven't done the math and checked what is as built, but it's very, very close to compliance. As far as safety, I want to respond to Ms. Turner. The pool meets all safety code. I inspected it. I'm a licensed contractor. It does meet setback and all building code requirements. And Sergio, I would have objected to you a couple times, but I think this council is going to beat you up on their own. So, but most importantly, I think it's important you had stated early on that the town under municipal code can call what they want. And I just want to remind you that structural coverage and structure would be clearly defined, as rule of law and preponderance of evidence in consideration of every other town, every other city doing it a particular way. You'd have a stiff argument before you stating that you could call an apple an orange within Monte Sereno, respectfully. But, I love all your questions. I'm happy. And I think if I could ask that you consider that the pool actually be permitted, not a variance. We have supplied all of the structural, mechanical evidentiary. We have a full photo, a record of all the trench depth, any tracing, all the bonding. I think that Ali would concur. I don't know if he's on board. I don't see him on the screen. I saw him earlier. But I think the town civil would be consistent with all building electrical mechanical code requirements. If we could get past planning and understand that the pool was built in complete conformance with permit requirements, with the exception of the misunderstanding of pervious impervious coverage and or what is being considered for many years within Monte Sereno as structural coverage. Thank you very much, all of you. Thank you very much.
Thank you, Mr. Benison. Mayor Pro Tem Mekachek, you have some final comments.
Oh, yeah.
Go for it.
So with respect to what's happened, my experience, and I'll stack up my experience, having obtained and finaled probably 7 to 9 permits with the city of Monte Sereno, including a swimming pool permit. It was perfectly clear to me that there's 2 tracks. One is the planning tract and approval, and the second is the building permit itself. And the building, those are two separate tracks. And the planning department, which was Ms. Hamilton, she looked at something different than what the building official looked at. And I believe that, well, so I can see the building official saying, okay, from a building permit perspective, all of the code requirements are met. And I believe the evidence shows that he identified that the planning requirements for the structural coverage were not met. And these are two tracks. And I think that in my experience, whoever is pulling the building permit has to be managing both of those processes at the same time. And if they're not, that's their issue to deal with. So my findings are that a swimming pool is in fact a structure. And the swimming pool is included in the structural coverage. I believe that the city of Monte Sereno is the jurisdiction having authority, and that's a building code terminology. But I think that if the city of Monte Sereno defines a swimming pool as a structure and includes it in structural coverage, then if Atherton, Hillsborough, Los Altos Hills, if they define it differently, then that's okay. We have come across this before in a number of different areas where our neighboring jurisdictions, for example, the county, and in particular, Los Gatos, if they define something differently, then I do believe that we should try to amend our regulations so that we're consistent with those. And a recent example of that would be our fence regulations, which we changed so that we're consistent. I am very distraught by the perspective that the prior owner / builder took. And I believe that he knowingly proceeded, my finding is he knowingly proceeded with the building of the swimming pool, knowing that he did not have a permit. And I believe that Mr. Benison testified a number of times that he made that mistake. He, the owner builder, made that mistake. And with respect to what what we'd like to do to rectify this, I would like to continue this hearing so that we can understand what the alternatives are, so that we could do something that is not extremely punitive to the new buyers. And it's a horrible way to be introduced to the city of Monte Sereno. And I'm ashamed that the prior owner / builder did that and left them holding the bag like this at the last minute. So again, my findings are the pool is a structure. The pool is included in the structural coverage. I believe it is a violation. And I'd like to continue this at a later date so that we can understand what the alternatives are with respect to remediation. And I do not believe that we need to, I believe that there's another alternative other than simply removing the swimming pool in 90 days. Those are my thoughts.
Thank you. Councilmember Luthor, please go ahead.
Thank you. Yeah, so I'll try to be as brief as possible. First of all, with respect to the mayor's comment about specificity, I read that as completely wrong. The city answered that question correctly, and 15 and 16 reconcile perfectly. 16 includes buildings and, actually the word or, buildings or other structures. And other structures are defined to include swimming pools. So echoing Mr. Mekachuk's findings, pools in Monte Sereno are absolutely a structure. It has always been that way. I have a pool permit and I have coverage limits, and there are rules that apply to everything. Also echoing what was said, this is on the prior owner. I'm so sorry that the buyers are faced with this. The housing market is what it is. They have inherited the problem. I am concerned about Mr. Benison's comments that are very disrespectful to the city of Monte Sereno and to our code and to the way that things have been done here. We have followed the rules. The owner did not follow the rules. And to tell us that, or even begin to suggest that the city has done something wrong is absolutely incorrect. To suggest to the owner indirectly or directly that they might want to bring a lawsuit to talk about ambiguity when there is no ambiguity is reckless and improper. The violation is clear. The pool is structural, and my only divergence with Mr. Mekachuk is that he suggests that he would love to see this continued to try to find a solution. The problem is there is no solution. The pool will always be structural. The violation, which is what we're voting up or down today, is 100% clear. And the variance, we aren't deciding that. But again, talking about what the legal standards are, I've looked at variances. We've all seen variances come before us. It is about the use and enjoyment of the property in the same way that the neighbors are entitled to. So last comment here, we all signed on to preserve the rural character of Monte Sereno. And quite frankly, Mr. Stimpson's design and then violating the rule knowingly and creating a home which is now with these structural elements shoehorned onto a lot that it does not fit on is inappropriate to the city of Monte Sereno. That's what's wrong here. If we were to find a solution, that solution has to apply to everyone else who then violates the law, presents us with a sad situation of something that was built to code and they really don't want to destroy it. So that's not how things work under the law. And I don't see any solution. It is our obligation, and I'm very sad to enforce it because I think it's a beautiful pool and a beautiful family, but it is our obligation to follow the law, which in this case is to find the violation. When there's a violation, it has to end in removal. It's not a place for us to get creative. We've got to make that finding, and continuing the hearing will not change that. Thank you.
Okay, Councilmember Mayor Pro Tem Mekachuk, did you want to add something? You're on mute.
I was going to wait until after Councilmember Lawler.
Oh, sorry. Go ahead, Councilmember Lawler.
Thank you.
Mayor, if I may, I believe we have one hand raised for public comment. Because we are a Brown Act body, we do have to take public comment on this item. And I would suggest giving the appellant 1 minute to respond to any issues raised in public comment.
All right, let me go ahead and finish with council, and then we'll go to public comment. Councilmember Lawler, did you want to go ahead?
Oh, I was just going to piggyback on what the others had said, and that we have to be, you know, this code exists for a reason, right? And we're trying to preserve the beautiful rural open feel of our community. That's why these rules exist, and that's what made you fall in love with our community. It's a terrible situation to be in. We have a builder who came in 2014, bought a house, tore it down, built it maxed out to the maximum square footage, and built a pool, and knowing he was doing so without a permit. So I feel really, really bad for you guys. At the end of the day, though, we can't let builders come in or anybody come in and just, consider the rules don't apply to them. That's setting a precedent, and these guidelines exist for a reason. So that's my comment, and I thank you.
Thank you. Let's see. Are there any public I guess Councilmember Luthor, did you want to add something else? No? And Councilmember Mayor Pro Tem Makachuk, did you want to add something else?
Yes, I was just going to say that when we're considering the alternatives, Councilmember Luthold, where I was going with that is perhaps half of the swimming pool or part of the swimming pool could be demolished so that it would go into compliance. And I wanted to go and crunch some numbers to determine if that was feasible or not. But that's where I was going. Thank you.
All right. And I do want to respond to my analysis of the interpretation of the statute. I think the issue really isn't what is structural and what's not, and what's structural, but what is structural coverage. I understand that the pool is structural, but the problem is the definition of structural coverage is the one that controls. That says 49% or 50% of the building can be structural coverage. So if you look at the definition of structural coverage, pool does not fit under structural coverage. It fits under structure, but the thing we're dealing with is not structure. We're dealing with structural coverage issue, whether the applicant went beyond what is allowed as structural coverage. And I think we do need to separate, otherwise we don't need two separate places to have definitions of coverage and structural coverage. There's obviously a difference between the two, and the difference in the structural coverage is fairly clearly defined as being something that's, if it's beyond the walls, it's not structural coverage. And that's where the problem comes in. The 50% applies to structural coverage. It doesn't apply to structure. Otherwise, it would just say it applies to structure. So that's my problem with just latching onto the structural definition and ignoring the structural coverage definition. All right, now that I've said my piece, I guess Councilmember Turner, go ahead.
Yes. I agree with Mayor Elahi here. I don't think that the pool is a structural coverage. And I think one of the things we need to look at is to look at the remedies that will not put a necessary burden on the new owners who had no knowledge of what was happening here. Perhaps what we can do is take a vote tonight on whether there is a violation or not, and then move on from there to correct any violation if so. But to vote and say, no, it's not a structural coverage, and then find them and say, go ahead and tear the whole thing up, I think is also not the right thing to do. We need to do the right things here. Thank you.
Thank you. Okay, this is the time to go back to the public. Is there any member of the public who wants to address us? Are there any hands raised?
We do. Phil Levine.
Mr. Levine, go ahead.
Can you hear me okay?
Yes.
Okay, hi, I'm Phil Levine. I'm not here to talk about myself, but as you guys know, I have been surrounded by lots of construction in the last 2 years, so this one really caught my ear. First, the family that moved in, you guys look beautiful, and it's really unfortunate. It's wonderful to see you in the neighborhood. Your girl's really cute. They look like mine 30 years ago or 28 years ago. The one comment the other gentleman made was this guy's background that did it. Monte Sereno at times reminds me of Lake Wobegon. You know, everybody's above average and women are strong. And, you know, there's a lot of really great people in this town. The people I've had problems with were, you know, heads of law firms, and I got an AT&T researcher. It doesn't mean these people that are wonderful can violate the rules, you know? I've got a real problem with that. And one of the issues I got is with the permit. If you're a licensed contractor, you should know you have a permit. And the one thing that I'm having problems with, and I had problems with, is there seems to be no accountability from the city back to the contractor. How can a licensed contractor not know they have a permit? And they have nothing to lose. If they'll make money pulling out the pool, they'll shrug their shoulders and they'll tell the original person, hey, I tried. But until you hold the contractor accountable for putting in something without a permit, I don't think the situation's ever going to change. So I tend to lean towards what Mr. Attorney Luthold said. I know that I'm an enrolled agent. A lot of you guys are lawyers. As professionals, if we're told to do something that's not legal or not professional, we are obligated to tell our clients no. I don't see that same accountability for the contractors. So I would urge you, no matter what your decision is, and this is complex, I don't feel strongly one way or the other, that you should hold the contractors responsible. And I do understand, I had this conversation with the great meeting that Liz Lawler set up with the city, that the contractors are basically accountable to a state organization. Kind of like the 1-6 committee, that doesn't mean the city should be off the hook. You guys could write a referral letter to the organization to hold the contractors accountable for doing something without permit. So just because they're not under your direct control doesn't mean you can't job on and influence them. So I would like you to encourage that people use permits. If you cheat once, everybody has an excuse to cheat. And the family that bought the house are absolutely beautiful, and I feel badly for you. I'm not a lawyer. I personally would go explore suing the person that sold it to me under false pretenses, but again, I'm not an attorney. And I thank you for your time. You got a difficult decision, but again, bottom line is you're not going to fix a situation until you really hold the contractors and their professionalism accountable. Thank you very much for your time.
Thank you. Are there any other members of the public who want to address council at this time, other than Mr. Benison? Okay, I don't believe there are any other hands raised. Mr. Benison, did you want to respond to Mr. Levine or any other comments?
No, I appreciate his comments. I think all contractors should be held accountable. It's one of the biggest problems we have in California right now. Contractors should be held accountable. I was not the contractor on this project. This was an owner-builder project. And as we mentioned early in the meeting, Bradley Stimson, he has a lot of experience. He's an engineer, and he has built 2 owner-builder homes in Monte Sereno. I'm all for contractors being held accountable. It's an epidemic in California. Thank you for your comment.
Thank you. Councilmember Turner? We bring it back to council. I don't think there's any other member of the public.
Let me ask you this. Do we have a contractor for this, or do we have an owner who acted like a contractor?
So the building permit application for the pool was submitted by the property owner. And since there was no building permit issued, it wasn't issued to either the contractor or the property owner.
So he wasn't acting as a contractor. I mean, he was acting as a contractor, but he didn't have a license. Is that correct?
So the property owner is allowed to pull a building permit under state law. And I think maybe Sergio can speak a little bit more to the legalities that may come along with that. But in this case, there was no building permit issued. So there wasn't an official contractor or owner builder for the project. There was an applicant that submitted an application, which was the property owner at the time.
So we had a builder, but he wasn't a contractor.
The property owner submitted the application as the property owner, correct?
But he built the pool. He built the pool, right?
I don't know who built the pool. We don't, because we didn't issue a permit. We don't have a record of who took responsibility for the actual issued permit.
Well, isn't
So
that
with respect to this particular issue, unfortunately, the city only has jurisdiction over the parties in front of it, which, for the purpose of this proceeding is the current property owners. Really, the city has enforcement powers over the property. And unfortunately, that means the city has enforcement powers over the present owner. Now, the city likely can't pursue remedies under the, against the prior owner as part of this proceeding. That, of course, doesn't mean that the Watts cannot pursue their own remedies in court with respect to the the seller and or prior builder and or prior contractors, if there were contractors on this particular property.
Thank you. Anything else, Councilmember Turner? Councilmember Luthold.
Yeah, thank you. Just one more thing briefly. As you, Mayor, and Councilmember Turner have suggested, the possibility to try to find a way to make this work is to talk about and create ambiguity somehow in the definition in section 6, attachment 16 or 15, and how those work together. And I understand striving to help these people. I've strived and strived to find solutions here, and there are none, and I'm very sorry about that. But Monte Sereno, there has never been ambiguity, and we have always been consistent that pools are structural coverage. They're treated that way in all the calculations. I'm sure we can go back many, many years. There has never been a pool that wasn't treated as structural coverage. And if we were to somehow say that the way the commas and the word or and the word walls interact in 16, which isn't really ambiguous, but if we reached for that, we would basically be creating the possibility that everyone in Monte Sereno could now come in and build any pool they wanted, because it wouldn't be part of their structural coverage. So that's something that we certainly don't want to do. We have to treat everyone equally. Pools are structural coverage. Sorry, that's the way it's always been. Let's not create a bigger problem for ourselves by opening up 1,200 homes to coming in and saying they want to do a bunch of building of pools because somebody on council tried to solve the Watts problems here. So that's not somewhere we want to go. That's not in line with our preserving the rural character. And I'm sorry that that's the case. So if we're ready to close whatever process we can go through for that, I know we do need to get to a council meeting, but we do want to give everybody their time and due process here. Certainly my vote will be, and based on the findings that I and Mr. Mekachek enunciated earlier, is to find the violation and to go forward with staff's recommendation. As I don't see any way to find any alternate solution given the realities of the case. So thank you.
Thank you. I understand where you're coming from, and I don't know if having pools really violates our rural character. My thought is maybe we could do something, which would be to promulgate an ordinance that clarifies that structural coverage does not include pools. If there is any ambiguity, maybe we can get over that. So I would suggest we move this hearing to a later date and to a time period in which we can propose an ordinance to provide that pools can be built in, under certain specifications and under certain guidelines, obviously keeping the building size and the lot size together, and allow people to build pools. And if we can move this hearing to a later date, once we had considered that ordinance, we may be able to grandfather this pool into that particular ordinance, because I think it's just a waste. I mean, to me, it's just a waste. The burden of proof is on the city to establish that this is covered. And just because the city's been doing it forever, because nobody contested it, doesn't mean that's the way to do it. It is currently a vague statute. It doesn't fit with any other city. It doesn't. The pools are good to have. Kids are having fun with pools. There's that to be considered. So I would like to see a motion saying, let's move this hearing down about 60 days and also start working on putting an ordinance together to allow some semblance of a pool that makes sense for Monte Sereno and keeps our character in place. Because I don't think there are many pools that are going to be built now, with everything else that's going on. But I think that may be a way to regularize this and avoid really what I would think would be just a waste. I mean, I just don't believe in a waste if it can be avoided. Thank you.
I guess if I may interrupt here, I have a question for the city attorney. Rather than, first of all, what are the rules on having this hearing and rendering a decision, on continuing the hearing if that's the choice? And as an alternative, would there be the opportunity to perhaps stay enforcement of the order to remove the pool so that the owners could work with the city on this. Changing our ordinance and our zoning rules is a long and involved process with multiple public hearings. We do have a housing element we need to get through. Certainly the burden on drafting the ordinances properly is maybe something these owners could help with. But we'd really be crafting an ordinance and changing our zoning for the entire city here. So City Attorney, what would be the timing on either staying enforcement of this to give an opportunity to see if something can be done, or to when do we have to make a decision on this hearing?
So I am not aware of any city code provision that would prohibit the city's enforcement hearing board from continuing this hearing, say for a period of 90 days. If that was something that the enforcement hearing board would want to do, and in the interim, the applicant or the appellant could petition the city council to direct staff at a subsequent city council hearing to initiate a zoning code amendment. So that is, I think, certainly a potential that the enforcement hearing board can consider.
Thank you. Anything else, Councilmember Little?
Sorry. So I would certainly be willing to consider this. However, as described, continuing at 90 days, putting it on our staff's plate to take a look at if, and obviously this is something that would have to come up as a council agenda item, and we'd have to look into whether that was something that the council wants to do. But if we wanted to look into potentially changing zoning so that we completely change the way we handle pools and how they affect our zoning and coverage limits, that's something that we certainly can look at. I would suggest, though, that despite how much we all want to help here, if we do go that route, there's no guarantees that the citizens of Monte Sereno want to have us change our zoning, and the council would do that. So I don't want to offer a false hope if we do continue the hearing, although I'm certainly willing to consider that, because I'd like to find a solution as well. I'm just not sure that recrafting the swimming pool rules for 1,000 people to fix one 226 square foot pool is really the best use of council's time and resources and city resources. But I'm certainly willing to consider it if my fellow board members here on this hearing want to go that route.
Thank you. Mayor Pro Tem Mekchek.
Thank you. Well, my finding is that there is a violation, and I'm not happy to make that finding. Unfortunately, we've got someone that has left town and has created this turmoil and this horrible situation. And again, I'm ashamed on behalf of the city of Monte Sereno. Having said that, I do not believe that someone leaving town and creating a problem like this can completely reprioritize what we as city council are going to do. And this is to consider changing the ordinance, I think is beyond, I can't even consider that at this point in time. The one thing that I can consider, as I mentioned before, is that we have a finding that there is a violation. And if there is a violation, then what is the remedy? And I'm not sure that we have exhausted all of the possible remedies. And I would like staff to spend some time, and the owners, the Watts, to consider and determine what the alternatives are so that they can be presented to us in terms of how we resolve this. given the finding that there is a violation. And I do not think, I think 90 days is too long to be put in a spin cycle on this. I think that everyone, including the citizens of Monte Sereno, need us to work a little faster than that. And I would think 45 days. So by the beginning of October. So that's when I think it would come back. Those are my thoughts. And again, I'm feeling really bad about this, but we cannot be dictated by someone that violated the law, did not have a building permit for the swimming pool, and then left town and left our new homeowners holding the bag for that. Thank you.
Thank you. Councilmember Turner, would you like to make a motion?
Yes, I would like to make a motion to move to 90 days and look for solutions and remedies for our new neighbors, and consider not only a variance perhaps, or even look at enforcement for future pools. So that is my motion.
Would you like to add, also consider amending the swimming pool ordinance?
Yes,
Bringing
yes, that too. Yes.
Thank you. All right, so that's the motion. Do I have a second on that? I'll go ahead and second that. Any discussion? If not, let's have a roll call.
Councilmember Turner,
Yes.
Councilmember Lawler,
No.
Councilmember Leopold,
No.
Mayor Pro Tem Mekachek,
No,
and Mayor Lahi.
Aye.
That motion fails.
All right, can we have an alternate motion to that, or we need something, I guess?
I would put forth a motion, or if I may,
Yeah, go ahead.
I'd put forth a motion that we find the applicant in violation, and we provide a stay or a continuance for a minimum of 45 days and a maximum of 90 days, so that we can, the applicant can identify alternatives other than complete removal of the swimming pool.
I'll second that.
Roll call, please.
Okay, Councilmember Leopold,
Yes.
Councilmember Turner,
Yes.
and Councilmember Lawler,
Yes.
Mayor Pro Tem Mekachek,
Aye.
and Mayor Lahi.
Nope.
That motion passes 4-1.
All right, I think we've had that discussion. That was the last item on our agenda today, so we can close this special hearing. And then we'll reconvene in about 5 minutes to our regular session, which is supposed to start at 7 p.m. Thank you, everybody, for your contributions. Appreciate that.